in this present day and age, we see that legal aid is an issue for a lot of people, and some people might not have funds to hire experienced, or for that matter lawyers at all, legal representation. How does the court view this situation? What happens to a person that just has to represent himself in the court?
Generally, Dinesh, a legal representative will be found for someone in a criminal matter. There's a lot of hearings that goes on before the actual trial itself. And from a law firm's perspective and from a solicitor's general knowledge, essentially the court will order legal, on certain special circumstances, legal aid will be found for those that can't afford legal representation. The process of fairness, the fair trial needs to be paramount in the Australian legal system.
Even in the Magistrates Court, they generally allow you time to find representations, whether they give you an adjournment or some time to find someone. That's generally the process.
It's an interesting question, In Australia, you have a right to a fair trial. You have a constitutional right to a fair trial. But you don't have a right to a perfect trial. You can't look at a trial and just pick out one error and say, well, look, my trial was bad and therefore I'm entitled to a retrial or I'm entitled to an acquittal.
Right.
Now, legal representation is not an absolute right. You cannot demand to a court. There was a case in the 90s called Dietrich and the Queen where the High Court discussed this exact question. And they said you don't have a right to a publicly funded lawyer or barrister.
Right.
And in fact, in that case, which involved drug trafficking, the legal aid had told that person, look, you can either plead guilty, in which case we'll fund a barrister to do your plea, or if you plead not guilty, you're on your own. And he was on his own, and the High Court said that although you don't have a right to a publicly funded lawyer, you do have a right to a fair trial. And if not having a publicly funded lawyer means you won't get a fair trial because the charges are very serious or it's a very complex matter, then you will get a publicly funded lawyer. Now, what the court can't do is to order legal aid to say, look, you have to provide this person with a barrister. But what they can do is say, we are not going to have a trial until you fund a barrister or a lawyer, and so they can just stay, which is just a fancy word for stop, the proceedings until that person gets a lawyer.
And I think Harlis is exactly right, and from a practical point of view, the more serious the matter is. So if you go to a trial in the county court or the Supreme Court, we are faced with very serious consequences. And that's generally when we have issues about legal aid funding and the court starts intervening in terms of making sure that the fair process is gone through.
And, generally, Dinesh, this is because it's most oftenly seen where people who appear on the preliminary view that they're guilty are generally most in need of legal representation.
So name some of the risks that someone would face if they're not represented.
Well, some of the risks would be not giving evidence properly. For example, when you say, or when we were talking about the prosecution would put forward their case, and then once the prosecution does that, you can just go straight to closing and technically someone can just say, well, I'm not guilty and sit down. But that would not reasonably be the fair process to go through. So if you don't engage a lawyer, if you don't engage in proper legal help, you don't know what to do in calling witnesses and
the complex
like
legal process,
exactly.
How to answer the question, what is a legal question, and so on. All right. So how do judges rule on this if a situation arises, if someone is not represented?
Well, a judge will probably consider the Dietrich and the Queen decision and will consider whether the person will get a fair trial or not in all the circumstances. And there's not a closed list of things to consider. It's a very open question. And then I probably jumped the gun before, but if they consider that without a lawyer that person will not receive a fair trial, then they will simply stay the proceeding, temporarily stay the proceeding until one is obtained.
Right. Yeah. Legal representation is not an essential precondition of a fair trial if the accused refuses representation. But let's move on. What is the sort of the manner that you should be giving evidence?
Well, the usual way in which people give evidence is by sitting in the witness box. Some people say stand. It's not stand, that's American. Witness box. And they just give evidence in court. But of course the the court has a lot of powers to control its own processes. The Criminal Procedure Act gives the court power to allow witnesses to read statements in advance, for people to give evidence through, for example, teleconferencing, which can be a very expensive process. Can be very expensive, but certainly there's power to do that, and it can happen.
There's also definitely ways that the Criminal Procedure Act can be used to protect certain witnesses. For example, child witnesses and people like that. They will not be in the same court as the person who allegedly committed the crime against them. They'll be in a separate room. There'll be a special hearing. So there's a variety of ways that people can give evidence in the dock. It's not just them to be in the courtroom giving evidence.
That's all the time we've got for you today. I'd like to thank the panel for joining us. If you want to catch up on our past episodes, you can visit our website, www.lawhelpaustralia.org, or you can just do a simple search by going to the YouTube channel or Facebook. Just type in Law Help Australia. If you have a question, if you want to join the panel, just email us on info@lawhelpaustralia.org. Bye for now.